Good morning, everybody. It's good to see some of you and some of your photos and your names. It is right at 9 o'clock, so we're going to go ahead and get started. But like we know, KSAE members are a little late, so they will be rolling in here soon. But I'm really excited about this week, and I'm glad to see all of you. I am going to hand it over to Miss Brandy Johnson right now, and she's going to introduce our first speaker.
Good morning, everyone, and welcome to our first ever virtual conference. Like Christy said, I'm Brandy Johnson with Johnson Association Services, and I'm a member of the KSAE Conference Committee. So quick shout out to our conference committee members, and especially Christy for all of her hard work and turning our conference virtual, and I'm looking forward to this week. So I know that everyone is probably familiar with Zoom at this point, but just a little refresher on logistics. At the bottom of your screen, you will see a chat button. We're going to use that and also the raise hand option for questions. So we'll make this an interactive session. Jeff's got a lot of great stuff for us, and so I'm sure we'll have a ton of questions. And also, please make sure you're muted if you're not speaking or asking questions. And now to our first speaker. Jeff Tenenbaum is one of the nation's leading nonprofit attorneys and also an accomplished author, lecturer, and commentator on nonprofit legal matters. As managing partner of the Washington, D.C.-based Tenenbaum Law Group, Jeff counsels his clients on a broad array of legal issues affecting trade and professional associations, charities, and other nonprofits. For 19 years, Jeff practiced law at the Venable Law Firm and chaired its nonprofit practice for most of that time. Among numerous other honors and awards, Jeff was the 2006 recipient of the American Bar Association's Outstanding Nonprofit Lawyer of the Year Award, and is one of only 5 lawyers in the prestigious U.S. Legal 500's Not-for-Profit Hall of Fame. Jeff is the author of the ASAE published book, Association Tax Compliance Guide, and currently serves as chair of the American Bar Association's Trade and Professional Associations Subcommittee on ASAE's Legal Advisory Council and Public Policy Committee. I've had the pleasure of seeing Jeff speak several times, and I'm really looking forward to it again. So I will turn it over to Jeff.
Thank you, Brandy. Good morning, everyone. Welcome to our session this morning. I know it's early, a little earlier for you than for me. I'm in DC, but this session is going to require you to wake up and ask a lot of questions, because this entire session is going to be driven by your questions. I am going to be talking about a wide variety of legal issues facing associations in the face of the pandemic that we are all dealing with. There are a lot of legal issues that have arisen over the course of the better part of this year that we've been dealing with this pandemic. Many of them relating to meetings and conferences, but also a lot of related issues. So when it comes to virtual conferences, issues relating to office reopenings, liability waivers, governance challenges in terms of membership, the inability to have in-person membership meetings and resulting membership voting, and a variety of other issues. These are all fair game. I've done sessions like this multiple times in recent months. We've never had a shortage for questions. We tend to start out a little bit slow and then people get going. Feel free to ask your questions verbally if you want to unmute and just ask, or if you want to put them in the chat box. And I think either Brandy or Christy are going to be kind of fielding those questions and kind of asking them to me. And if you want to ask any questions on any association legal issues that are not pandemic related, that is absolutely fine as well. As you heard from Brandy, I've spent my 25-year legal career in private practice, all of it exclusively representing associations and other nonprofit organizations, primarily as outside general counsel. So I've worked with, at this point, probably thousands of associations on just about every conceivable legal issue that they face. I started Tenenbaum Law Group at the beginning of this year with another lawyer, and it's a boutique based in DC that exclusively represents associations and other nonprofits. So I have dealt with all of the legal issues that your associations deal with every day. I've dealt with them for 25 years for lots of different associations. So what I will be talking to you about is informed by all of those experiences. So nothing is off limits, but if there is there are a few topics that I don't have specialty expertise in and that I outsource to others. If we happen to come across one of those, I will let you know. But otherwise, feel free to ask me anything about any legal issues. So who wants to get us started on something you'd like to hear about, a challenge that you're facing, something you'd like to know a little bit more about? Let me let me know what you want to start out with.
I know, Jeff, we have a lot of meeting planners on here, so maybe if you could speak a little bit to some of the legal issues we may be facing when we get back to in-person meetings, or how to speed bump those, maybe.
Sure. So I'd say the two biggest questions that I get almost every day from clients relating to kind of the eventual return to, and not just eventual, some associations are already having in-person meetings. Most have not, but most are contemplating them at some point in 2021. And so the two biggest legal issues and questions that I get, one relate to how to mitigate the association's liability risk from holding an in-person meeting where there is a risk of attendees contracting the virus. And the other is, how do we mitigate our potential financial losses from the attrition penalties that are in our contracts for guaranteed and minimum sleeping room revenue and food and beverage revenue? So even if it's an event without sleeping rooms, you generally have minimums for both of those, sleeping room revenue and food and beverage revenue. If you don't meet those minimums, you get hit with what are called attrition penalties. So this is very different from cancellation penalties that I've spent enormous amounts of time over the better part of this year working with associations on trying to get out of their in-person meetings in order to hold virtual meetings instead, and trying to mitigate or eliminate the cancellation penalties. Attrition penalties are when you actually go ahead with the in-person meeting, and they're designed to try to provide a minimum floor for the venue, usually in your case, probably hotels, the minimum floor revenue that they're going to receive. And so if, let's say you have a meeting planned for, I don't know, May of next year, we're dealing with a lot of spring meetings right now, counseling clients through that. In April, May, June, and any time like that next year, most people do not believe that the virus is going to be completely behind us by that point. Hopefully things will be a lot better. Hopefully vaccines will be fairly widely distributed by then, but it's still going to be out there. There's still going to be risk. And as a result, and there's still going to be employer imposed travel bans. There may still continue to be state and local governmental restrictions on travel and mandatory quarantines when you come back from travel to certain places, wherever there may be hotspots at the time. And so the result of all of that is that your May 2021 in-person meeting is not likely going to get the same attendance as you would typically get in a non-pandemic year, pre-COVID. And if, let's just say, you have 50% less attendance, if you have attrition penalties in your contracts, like most of your contracts do, then you have the potential to get hit with very significant potential financial penalties for failing to meet those minimums. So the most important thing you can do if you are contemplating having an in-person meeting next year, maybe a hybrid meeting, which a lot of associations are planning for, you have to reach out to the hotel. I would recommend sooner rather than later. I would actually do it now, for essentially any meeting next year. I think you're going to have a little more of an advantage right now where the hotels are really struggling. Not many associations and others are having in-person meetings. You're more likely to have success in your negotiations if you say, look, we want to go ahead with this meeting. We don't want to cancel, but we're here. We've surveyed our members. We've talked to a lot of folks, members, speakers, sponsors, exhibitors. They're not all going to show up. Even for a meeting in the middle or even later next year, we still think we're going to have trouble getting everyone there. So if you want us to move ahead with the meeting and not cancel, we need you to work with us and reduce the guaranteed minimums for sleeping room revenue and food and beverage. In some cases, we've had a number of hotels that are willing to waive attrition penalties altogether. That's getting tougher to do. And I think the later in the year it gets, beyond, say, the first quarter, that's going to be a lot harder. But most associations that we've worked with on this have had a good degree of success in reducing those guaranteed minimums for the sleeping rooms and the food and beverage revenue. So as to the, and I'm sure we're going to get some questions here about cancellations as well and strategies there. But as to Brandy, the other part of your question, or the other part of in-person meetings, the question I get all the time, liability risk. It's a bit of a moving target because the standard here is one that lawyers call negligence. It means in going ahead and holding your in-person meeting, were you negligent in not meeting the prevailing standard of care at the time? And so, of course, you're asking, what is that standard of care? Where do I find it? Well, unfortunately, you can't find it in any one place. You find it in multiple different places, and it's constantly changing. It's basically, what would a prudent, responsible association do in holding its meeting? And if you do those things, then you're not likely going to be held negligent, and you are not likely going to be held liable if an attendee contracts the virus at your meeting. Now, of course, in this area, we have the issue of causation as well, which is very difficult when you're dealing with COVID, because it's very difficult to prove where someone contracted the virus. But we do know that if there's an outbreak and multiple people contracted at the same time and they're all in the same place, it's fairly easy to track it back to your conference if that indeed happens. If it's just a one-off, one person comes down with it, causation is going to be extremely difficult for them to prove. But regardless of causation, you don't want your attendees to get sick. You don't want the reputation of your association to be one where you went ahead with an in-person meeting and, a number of folks contracted the virus. You just don't want that. So what should you do? So you should do as many things as you can possibly do to meet that standard of care. You start with looking at what are the applicable state and local requirements, legally required things that you're required to do. Many states and cities and counties have requirements for in-person gatherings where you have to do certain things like wearing masks and social distancing and sanitation measures and things like that. So you first look to what is legally mandated because right now there are no federal mandates, they're just federal advisories, recommendations. The mandates come in some states and cities and counties. So you look there to see what's mandated. Then I would look to the CDC, because the CDC has two sets of guidance for large gatherings. And I forget, Christy, did I send you or Brandy articles of mine to share with yeah, I did. I shared a number of articles with Christy that she either has or will be sharing with all of you. All of the articles I've written on all of these kind of pandemic related legal issues for associations. And a couple of those articles have links to the CDC guidance. So you should look at that CDC guidance. It's very detailed. It's very helpful. Some of it is going to relate to things that you, the association, need to do. And some of it is going to relate to things that the venue, like the hotel, needs to do. But you want to do as many of those things as you can reasonably do and can afford to do. And you want to try to get the hotel to commit to do everything that kind of falls into their bailiwick, things like sanitation protocols and other things like that. How food is served and all those things that are really going to be on the hotel. But in order to show that you are not negligent, and frankly, to help protect the health and safety of your attendees and your employees, you want to make sure that there is an affirmative commitment from the hotel, even if it's just an email exchange, some sort of affirmative commitment by them to do their part to abide by all of those protocols. So if there's other kind of standards, there's other things that help inform the standard of care out there, like in Michigan, there's a coalition of government officials and association folks and Chamber of Commerce and CBB that put together this safe meetings guidance for how to hold safe meetings, in-person meetings in Michigan. But the guidance is, relevant everywhere. Take a look at things like that. And as many of the things as you can do, you should do, document the fact that you're doing those things. And that'll go a long way to help keeping your association liable for negligence in the event that someone contracts the virus and can prove that they contracted it at your event. The last thing to kind of throw into the mix in terms of your risk mitigation measures is liability waivers. And I get asked a lot about this. Should our associations planning on going ahead with an in-person meeting, should we require our attendees to sign some sort of a liability waiver, where something that says, I know that the COVID is a very risky, dangerous virus. I recognize the risk of attending an in-person meeting, and if I do in fact contract the virus at your meeting, I agree to hold the association harmless and not hold the association liable because it was a knowing assumption of risk. That's essentially a liability waiver. Do I think you should require your attendees to sign one, at least for the time being? Absolutely. no question. I think it's going to become a standard. It already, frankly, has for so many businesses that are open. If you go to, name it your hair salon or your gym or other things like that, in most cases you have to sign a waiver that says you agree not to hold them liable, and you're also attesting that you don't have any of the symptoms and things like that. I think you absolutely should do that. It's an important tool in the kind of the toolkit of risk management for in-person meetings, but it's not the end all be all. It's not going to absolutely save you. Liability waivers get tossed out by courts all the time for different reasons, but you would be crazy not to go ahead with one. I don't see any reason why you want it. You can make it, you can water it down, you can make it a little more innocuous if you want. But the other thing that I put into the liability waivers that I've written, and the first one I wrote was for one of your sister state societies of association executives, the Georgia Society, had an in-person conference at the end of August, and I actually went and spoke there in Savannah. But I drafted a liability waiver for their executive director to use, and they had the attendees sign. And then I later turned it into kind of a model waiver that I wrote an article about that you guys have. So you'll have a copy of that model liability waiver. But in addition to the liability waiver part, I added a portion in there that basically is kind of a conduct attestation by the attendees, meaning I attendee agree, to follow all your rules in terms of mask wearing and social distancing and hand sanitation and things like that. I agree to not show up if I have any symptoms of the virus or I'm not feeling well. I agree to not go off site and engage in risky activities that could endanger other people. Those sorts of things, I think it's important to add those in. Again, it's another step in liability mitigation, but it also, will help hopefully incentivize your attendees to basically follow the rules. So that's a lot to digest. Why don't I stop there? I saw some questions that came in. Brandy, if you want to pose the ones that might be relevant to this topic.
Okay, so how much of the cost associated with meeting guidelines should the hotel absorb and not pass on to us as associations?
It's a great question. And the answer is whatever you can negotiate. To the extent that these are things that logically fall on the hotel, like all the sanitation protocols, you shouldn't have to have your staff or volunteers, going around and spraying and wiping down surfaces and things like that. Making sure there's good air filtration systems. I mean, that's not things that should fall on the association, whether they're mandated by state or local law or whether they are guidance, from the CDC or elsewhere. It really should be incumbent on the hotel to do those things, and you should pressure the hotel to commit to doing those things. Every hotel is saying right now, yep, we have all these great protocols in place. All the big hotel chains have guidance that they've given to the local hotels. But when push has come to shove, in a number of cases that we've been involved in, we've had associations kind of walk through with the hotel all the various things that they should be doing. In virtually every case, they weren't doing nearly enough, not even close to enough of what they should be doing. And part of the main reason is there's costs involved, and hotels are really struggling. So they don't want to incur extra costs that are non-revenue generating. But you need to get them to agree to do that and to try to cover those costs. Now, things like, are you going to be able to require the hotel to have someone stationed at the front door to take temperature checks of everyone that walks in? Maybe, maybe not. You probably would have a hard time doing that, especially when they're short staffed. But that is something that perhaps you guys, could have someone stationed at the front of your, ballroom or something else, to take everyone's temperature as they walk in, for every session, things like that. Policing the wearing of masks and policing social distancing. The hotel is not going to do that. That's something that's going to fall on you. But frankly, if you look at that CDC guidance, most of it actually applies to the venue more than it does to your association. And you want to get them to affirmatively agree that they are going to do as many of those things as possible and to pay the costs.
Here's another one that kind of follows suit. Does the venue bear the burden of responsibility for knowing and enforcing the local standard of care? If an in-person attendee at a hybrid conference reports a positive COVID test 15 days after the event, does the association have the responsibility in contact tracing?
First off, there's no federal mandates when it comes to things like that. It's all state and local. So you got to look at what your state and local laws require. We know that even when there are state and local requirements, like where I'm in, and DC has some pretty strict requirements, but they're generally not followed. All these mandatory quarantines when people come back from other states, most people are not following from what I can see. Mandatory contact tracing is not happening in a lot of cases. But certainly if there is an applicable state or local mandate on something like that, like an affirmative obligation, if someone reports a positive COVID test within 2 weeks of your event to notify the hotel, then obviously your association should do whatever it can to follow and abide by those guidelines and notify the hotel. But I think the question was more, does the hotel have an obligation to follow that state, whether they're mandates or whether they're guidance? Either way, yes, the hotel should be following them, but you are likely going to have to light your feet under their fire to make sure that they're complying with all those things.
I'm not seeing any more in chat. Christy, is there any hands raised that anyone want to ask in-person questions?
Any other questions on in-person meetings?
Real quick, back to liability waivers, Jeff. Is most of us obviously take our registration online. Is it acceptable to have that waiver there on our conference page and then have them check something within their online registration stating that they, agree to the terms of our liability? I assume we can do that and not have to necessarily have them sign those in person.
Absolutely. No problem in doing that. But the thing I recommend is that you don't just bury it in a bunch of other, here's all of the rules of our meeting. Because, a lot of associations, I've drafted them over the years, for in-person meetings and for virtual meetings, have all these kind of rules of the road, conduct. There's a lot of, in recent years, codes of conduct have become more popular. You agree to abide by our code of conduct, you agree to discipline or even being kicked out if you don't abide by it. Things like a release for taking photos and videos, by registering for the conference, I agree that you can take my photos and videos without my, express permission. Things like that. Don't just bury them within those rules. Those rules are still important, and you still want to have something that says by registering, I click and accept that I agree to all of these rules. But for the COVID liability waiver, I would have it kind of jump out like a pop-up box or something that has it, and then they have to affirmatively click and accept. Maybe even type in their name or something where there's some real affirmative consent that they have read it and they're agreeing to abide by it, and then keep a record of that. But yeah, doing it electronically is obviously how most associations will be doing this, and absolutely no problem with it.
Great, thank you. Here's another question along those lines. If the hotel, if a conference, for most conferences, when you do registration, someone will sign up multiple people. Do we need to have a signed agreement from each individual, not just the person completing the registration for multiple people?
So like if a company, for instance, is registering multiple of its employees.
Right.
Yeah, you really, that's an example where I could see if it ever got challenged, a court tossing that out, saying, well, the HR manager who registered everyone might have, agreed on their behalf, but he or she didn't have the authority to do that. It wasn't kind of a knowing waiver of risks. I would strongly recommend that not happen, that you have some mechanism where each individual attendee has to affirmatively click and accept that they agree to the COVID waiver, frankly, along with the other rules, that hopefully you have. I'm not saying you have to have a code of conduct, but you definitely need to, you should have a code of conduct, because we've had so many issues in recent years with kind of bad conduct at conferences. Usually involves drinking and usually involves kind of inappropriate contact, word spoken, things like that. I get involved in these things all the time because they bring me in after the fact to figure out what to do about it. And where you have a clear kind of code of conduct that gives the association, plenty of leeway to take disciplinary action against, bad behavior, it can be very helpful. So for all of those things, you want the individual attendees to agree that they will abide by those rules.
Great, thank you. And just to remind everybody, he did send the link, and he has a sample of a liability waiver on that. So Christy sent that out to everyone yesterday. Here's another question. If the hotel says you can still hold your event just with reduced capacity, is there anything we can use to say it's basically not the event we planned on to receive some kind of a refund? And she may want to clarify a little bit more on what she's speaking to as far as a refund on that, but
Yeah, is that Rebecca?
Yeah. So basically, we're working with a big trade show, and they're telling us that we can still do our event because it's not until February, just at reduced capacity. Well, when you have a trade show, there's an issue with if you don't have a lot of people there, people are gonna, so it's not the event that we planned with the attendance that we had planned, but they're telling us that we can still do it and not letting us out of our contract because technically we can still have our event with just 25% of our people.
Okay, so I'm glad you raised this. I didn't mention that before, but right now, most cities and states and counties have capacity restrictions, is what we refer to them as, on venues. Restaurants, in some cases, things like movie theaters and hotels, like meeting space and things like that. Most states and cities where large gatherings up to sometimes there's numeric limits on how many people can be gathered. And right now, because we're having such a bad outbreak of the virus again, a lot of those capacity limitations are down to like 10 people. But in other places, they're not limited by the number of people, but they're limited by percentage of typical full capacity. You see 25%, 50%, things like that. Right now, we're seeing a lot of 25% capacity restrictions. And so, obviously what that means is that, if your conference usually, put the venue at full capacity and say, I don't know, that was 500 people. And, now there's a 25% limitation, so you're down to, 125 people. If they can only legally allow 125 people into the venue when you contracted for 500, because that's what the law is requiring of them at the moment, they are in this is my opinion, they are in what's called anticipatory breach of contract, meaning they are going to breach the contract because they can't fulfill what you contracted for. I pardon my language, but it's really bullshit that they're telling you that you can still go ahead and then there's nothing wrong. You can only have 125 people when you contracted for 500. That's just wrong. You contracted for 500. If they can't accommodate 500, now, given we know the reality is that you're probably not going to get 500 people in February, but that's what you contracted for. And so I would take a hard line. We've done this in a number of cases and had some great success with it in either negotiating the client's way out of the contract altogether, or getting them to waive attrition penalties, or doing a rebook for a future year, but getting them to waive the cancellation penalties. Whatever the outcome is, and there are multiple different outcomes, you need leverage to get those outcomes. So I'm going to talk in a second about meeting cancellations and postponements, because it all relates to this, right? These things are interrelated. Whether they can't accommodate you as contracted, and if you're not, say, really eager to do a meeting in February, which most associations are not, because most people don't think we're going to really be beyond this until probably the middle of next year. Maybe in a little better in the spring, but really not beyond this until probably next summer in a meaningful way. You may want to get out of it altogether or postpone it, but to do so, you need leverage. And the hotels are pushing back harder than they ever have, even though we're in kind of this incredible spike right now in the virus. They have kind of overall seem to have really gotten tired of agreeing to all of these cancellations and postponements without penalty, and they're increasingly pushing back harder and harder. I'm dealing myself with more hotel lawyers than I ever have before, because a lot of them are playing hardball with cancellation penalties and then sending it over to their lawyers. So you need leverage, and that is an important piece of leverage that you have. That ability to make that argument that they can't accommodate for what you contracted for. So let me talk a little bit about kind of cancellation. So for the first, 6 months at least of the pandemic, I gave a lot of these virtual webinars, and they were all pretty much all revolved around meeting and conference cancellations, and how can you try to either cancel or reschedule or postpone your meetings and avoid paying cancellation penalties. And some of the articles that I gave you relate to that topic. And there's a lot of strategy involved. And we've worked with hundreds of associations on even more conferences and meetings, probably advised on about at least 750 different meetings and conferences for associations over the course of this year. And so we've seen how a lot of this plays out. There's a lot of strategy involved, and the strategy and the successful outcomes are getting harder and harder because the hotels and convention centers are pushing back harder. Here's a few things to keep in mind. Timing is the most important thing. So let me take a step back. Most hotel and convention center contracts have a provision in there called the force majeure provision. Sometimes it's called impossibility, but it's all the same thing. And what it means is that it's a provision that essentially says if some unforeseen event occurs that makes it illegal or impossible for either party to perform under the agreement, then that party shall be excused from performance and excused from paying any cancellation penalties. Because most of these contracts have, almost all of them have provisions that say, if you cancel within X number of days before the meeting, and it's not excused by the force majeure clause, then you have to pay us cancellation penalties, which are designed to essentially make the venue whole for the profits they would have earned. So they can be very significant. And they're particularly crippling to associations because those profits are generally coming from your attendees, right? They're coming from the money that they're spending on sleeping rooms, and they're coming from money that they pay you in registration fees that you turn around and use to pay for food and beverage. So in the case where you're not holding the in-person conference and you have to make the venue whole for all of those profits, you're not getting a single dime from your attendees, except maybe to the extent that you can get some money from a virtual conference, but no one's making anywhere close to the amount of money off virtual conferences that they did in in-person conferences. So all of that comes out of your pocket, which is why there are some associations that are literally facing potential bankruptcy if they can't negotiate their way out of these cancellation penalties. Particularly associations that don't have deep reserves. And so it's really critical to do everything you can to avoid paying those cancellation penalties. So a lot of people will say, so I guess what really matters most is the language of that force majeure clause. How is it written? And yes, it's important because you want to be sure that your force majeure clause, and obviously you can't change it for a contract that's already been signed. It is what it is. But if you want to analyze it, you look at it, and most force majeure clauses have two parts. The first part says, if an act of God or an act of terrorism or other things or any other unforeseen event beyond the control of the parties occurs. That's the first part. You want to be sure that that first part contains either a specific reference to something like a pandemic or an epidemic or a communicable disease, or it has some catch-all phrase, like, or any other event beyond the control of the parties. And most of them do, but there are some that don't, that are very limited. They list a few things, but none of those is would cover this pandemic. If it doesn't have that catch-all phrase, it could be problematic. And then the second part of it is the more important part of the clause, and that is, what effect does that unforeseen event have on the party's ability to perform under the contract? I'd say 85% of all the force majeure clauses we look at say that the effect makes it illegal or impossible for either party to perform under the contract. The hotel lawyers take the position that the only thing that makes it illegal or impossible is if there is a directly applicable governmental ban on holding a meeting like yours at that particular time. Meaning, because there's no federal bans, a state or local ban on holding a meeting like yours. We don't necessarily agree that those are the only conditions. Those are certainly the easiest ones and the strongest ones. When you have an applicable state or local ban on larger gatherings, we believe that there can be other factors as well. But some force majeure clauses, in addition to saying illegal or impossible, also have language like inadvisable or commercially impractical. And if it has that kind of verbiage, it is a broader clause. It's an easier standard to meet. And it should give you a little more leverage when it comes to potential force majeure termination, meaning terminating without penalty. But the most important factor is timing. Because even if there is, say right now we're in beginning of December, and let's say like Rebecca's conference is in February. So let's say it's early February. So let's say it starts 3 months out. What we have found is that if there is a directly applicable governmental ban on holding your meeting, or even on holding your meeting as contracted. So I would take the position that, if there's a 25% capacity restriction on the venue, and therefore they can't, perform as contracted for for your full numbers that you had contracted for, that makes it, impossible for you to hold your event as contracted for. And that should allow you to terminate under the force majeure clause. But the problem is that we're still 3 months out, right? Your meeting is in February and we're in December. What we have found is that if you can wait until at least 3 months out, and the 90-day mark we found to be critical. If you can wait till 90 days out before the start of your meeting, and at that 90-day mark out, there is a directly applicable governmental ban, that if you pull the trigger on a force majeure termination, then you are likely going to be successful. Most of the hotels will not fight you on a force majeure termination as long as it's 90 days out or less from the start of the meeting. If you can get to 60 days, it's almost a surefire guarantee that you'll be successful, but at least you need to wait till 90. What we found is that associations that terminate earlier than that, further out than 90 days, have generally gotten great resistance from the hotels and convention centers in terms of accepting. Because what the hotel lawyers say is, well, yeah, there is a restriction in place right now, but how do you know it's going to be in place 4 or 5 months from now? You don't have a crystal ball. All signs are that, vaccines are coming and whatnot, and we should be good to go. So you are prematurely terminating, and we're going to reject your force majeure termination. And by the way, here's a bill for all your cancellation penalties. The timing is the most critical element. Now, the other thing that many associations have had great success with is using kind of this time-honored tool, technique that we've used in this area for years, which is to do a rebook, to rebook, a future meeting, a future conference, whether it means pushing this particular conference back 6 months, which might be a more viable option, say pushing a February conference back to the fall, or just, canceling, but, rebooking your next open year for your annual meeting, or whatever the conference might be. We have had many hundreds of our association clients have great success in doing a rebook and being able to either avoid cancellation penalties altogether, or at least negotiate them down to a very modest amount. Sometimes we've had associations have had to throw in some other, sweeteners into the mix, things like throwing in another smaller meeting, like a board meeting in some open future year, sometimes increasing the food and beverage minimums for a particular meeting, to make it more profitable for the hotel, things like that, whatever it takes to make it work. Sometimes, some associations have had, contacts like at the corporate headquarters for the chain, like Marriott or Hilton or whatnot, and use some of those relationships to kind of bring pressure. Some have utilized their relationships with the local CVB, to help negotiate a better outcome. There is no silver bullet here, no one size fits all. These negotiations are getting tougher and tougher. And particularly if your meeting is kind of beyond the first quarter of next year, it is going to be tougher, but it's still a technique worth pursuing. But like I said at the beginning of this discussion, you want to have as much, and you want to have and utilize as much leverage as you can. You need to make that leverage known. You need a credible threat of force majeure termination, or a credible threat of anticipatory breach of contract, to be able to get the hotel to agree to that rebook without charging you a lot of cancellation penalties. They're not going to do it generally out of the goodness of their heart. You need to put pressure on them. You need to have a credible threat of things like that in order to get the outcome that you're likely looking for. Why don't I stop there? I saw some questions came in.
Jeff, by chance, do you have sample language for force majeure regarding pandemic or COVID that people could use for future contracts?
So I think I sent this to you. I'll send it to Christy.
I looked through the stuff and I didn't see it, but maybe I missed it.
It's in, there's a core PowerPoint presentation that I used for months in the beginning of the pandemic. Some of it, it's likely outdated by now, but I have it posted on our site. I'll send you a link, and that has a model force majeure provision. Now, model from the association's perspective, the chances of getting any hotel to agree to that are zero. Not going to happen. They're not going to agree to something that favorable to the association, and we're seeing more and more pushback, of course, on the force majeure clauses, because they know how critical they are now. This is not a clause that a lot of people focused on before. It's definitely one that people are focused on now, but at least it gives you a starting point. It gives you a model. But to me, the most important thing is to try to get either that commercially impractical or inadvisable language, one or the other. You don't need both to get those in. And most of the hotels, they'd rather see commercially impractical other than inadvisable, because it has a certain legal meaning to it. So lawyers, know what that means. Inadvisable, they really don't know what it means. But yeah, I will send that to you.
Thank you. And Jennifer, I believe he may have answered this question, but Jennifer had asked, are you seeing success with getting COVID-specific clauses and or pandemic clauses included in force majeure language of hotel contracts? And I think you kind of just touched on that. But
well, yeah, so it's interesting. What we're seeing from some of the hotels, I think Marriott in particular, but I think some of the others too, is that because we are working on a lot of new contracts. So most of the rebooks, when you're just taking an existing meeting and you're essentially pushing it back 6 months or 2 years or whatever the case may be, 3 years, most of those are handled with an addendum that simply basically changes the dates and not much else. And that's generally the easiest way to negotiate these, is to not reopen the whole contract. But of course, the regular process of contracting for meetings is continuing. It's slowing down because a lot of associations are reluctant right now to contract for new meetings because they don't know what the meetings world is going to look like. We don't know, what attendance is going to look like in the future. So it's really hard to do. But a number of associations are moving ahead with their meetings. And what we're seeing from the hotels when they propose the contracts is that a number of them are proposing these provisions that on the surface look very friendly to the association. They're COVID specific, and they basically say, if there is a directly applicable governmental restriction that is in place 60 days out or less from the start of your meeting, then you can cancel without penalty. So a lot of people look at that and say, oh, this is great. And we don't even have to fight over this. They're agreeing to it. But my colleague and I don't like that provision at all, because what it does is it seems to limit your options there. First off, it's limiting it only to the governmental restrictions. So we have seen some clauses that are a little more favorable. They talk about like CDC advisories. But if it's limited to governmental restrictions, it kind of takes other things by definition off the table that you could use in a force majeure argument. But B, the most troubling part is that it limits you to that 60-day out window, which many, I'd say most of our association clients have told us they cannot wait until 60 days out to pull the trigger and make this decision on canceling an in-person meeting. There's too much pressure from their members. They just can't wait that long. So by having that language in there, almost by definition, it means anything beyond 60 days is not going to be acceptable in terms of a force majeure termination. So when you see language like that, I would either try to change that 60 days to 120 days or something like that, or just take it out altogether. But I feel like most associations, you can't wait till 60 days out.
I believe that's all the questions we have right now, but do you have any other hot legal topics unrelated to maybe meetings that we should be considering as associations, pandemic or otherwise?
One issue, and you might not think of it as a big issue, and it's not a big issue in the big scheme of things, but it's an important one. A lot of this, in some areas of law, there's one thing I've learned over the years is a lot of little simple, easy things you can do that if you do them, they're going to be really helpful to protecting your association in the future and avoiding bigger problems down the road. But a lot of associations just don't think of or even know to do some of these smaller, simple things. What I'm talking about in this particular instance relates to copyright law. And one thing that we've seen, from the transition from in-person to virtual conferences, like this one that I'm speaking at today, and if you look at the top, left of the screen, it says recording. This is what most associations are doing. They are recording their virtual conferences and webinars and other things to make them available to the registrants, to make them available to the rest of the membership, to maybe sell access to in the future, to maybe repurpose content in the future. Lots of different things that you can do with some pretty valuable content, right? You can monetize it. You can use it as a member benefit, other things like that. And as a result, it's really important that you make sure you have the full rights to be able to record the content and to utilize it in any way that you want in the future, right? So you're recording me right now. It's actually, I said copyright law. This partly relates to copyright law and partly relates to something called the right of privacy, which is a common law right. So we have copyright law and we have the right of privacy. When you're talking about getting permission to record someone, either photo, video, that is something that's governed by the common law right of privacy. For famous people, it's governed by the right of publicity. For the rest of us, it's governed by the right of privacy. And essentially, we all have a right to not be recorded without our permission. And so it has become a best practice for associations when you're recording people to get permission from those who you are recording. Mainly, I'm talking about your speakers, to agree to give you permission to do that. Back with in-person conferences, most associations didn't record their speakers most of the time because of the prohibitive cost of doing so. But here, Christy just presses a button and it's recorded and it doesn't cost anything. So you want to make sure you get permission from all your speakers to do that. And then where copyright law comes in, copyright law has nothing to do with permission to record someone, but because in copyright law, the person who makes the video, who makes the recording or takes the photograph is actually the owner of the copyright in that. So, you as the sponsor of the conference, KSAE, you own the copyright in the recording of this particular presentation. But when it comes to like the articles I sent you, now granted, I sent them as links. So the reason I'm explaining this is it's important for you to understand this in copyright law. When someone can, publicly, go onto a website, link to something, like all of my articles are posted on our firm's website and they're all freely available. There's no password protected or anything else. Whenever you share links with someone, that cannot constitute copyright infringement. But, it was sometimes, speakers will give articles in PDF format or Word format, or even, in old days in paper format, something like that, where it's not a link. If you then want to share those with your members and others, you need to have permission from the copyright owner to do so. In that case being me. So with the links, if you want to share them, you actually technically don't need permission to do it. But if I were sending you like PDFs of these articles and you wanted to share them, you would need permission from me, the copyright owner, to do so. Because even though I'm the copyright owner, there's two ways that a copyright owner can share his or her copyrighted works with someone else. One is through assignment, which means a transfer of ownership. So, say if you were purchasing something from me, or I was writing something for your magazine or journal and you were paying me to do that, you would probably insist on a copyright assignment where you get ownership of that, transfer of ownership. But in most cases, what associations do is they get a license, which is just permission to use the copyrighted material. Generally, it's a non-exclusive license, meaning I can still license it to others. It's generally a royalty-free license, meaning you're not paying for it. And it's generally perpetual, irrevocable, worldwide, etc. And so it has been for years a best practice for associations to get their speakers to sign a form, and it can be electronic signature, click and accept, but to agree or sign a form which A, gives a copyright license to all the materials to you, and B, gives you permission to record the presentation, photos, videos, etc., and use it in any way that you want. So that is what I strongly recommend. I've been recommending that for years. I know you're going to want it, so I will send you some, I have some model speaker forms. I have one version for like an in-person conference and one for virtual, and I will send those to Christy to share with you guys. And it has all of that in there. So it's got the copyright license, it's got the, permission to record. And then it has another important feature, which is what lawyers call representations and warranties. Basically, I, the author, am representing to you that the materials I'm giving you do not infringe anyone else's copyright. They don't defame anyone. They don't want to invade anyone's privacy. Basically, they don't break the law. Therefore, when you're using them, it mitigates your risk, the association, of contributory copyright infringement and other claims like that, which do happen sometimes in the association world. So you want to get that representation from the speaker that everything he or she is giving you is completely lawful. So I'll send you those forms, and I'll also send you one for authors. So when you have, your members, volunteers who are, writing articles for your magazines and newsletters and journals and whatnot, it's absolutely a best practice to get that same copyright license and reps and warranties from your authors for your written publications as well, for all the same reasons.
Thank you, Jeff. Real quick, if we're just doing a simple Zoom without handouts or anything related to that, is a simple email asking the speaker for the permission to record sufficient, or do we need a signed?
It absolutely is. It absolutely is. But you should do that. And frankly, but it's better to have the form, because the form has things like the reps and warranties, right? Like, I am representing, warranting that everything I say today, doesn't infringe anyone else's copyright, doesn't invade anyone's privacy, that I have permission to say what I'm saying, that it doesn't defame anyone. And there have been many suits over the years against associations for what speakers said at conferences. A lot in the medical field, where a speaker gave like bad medical advice or something, and then patients got injured, and then the association got sued for being negligent in allowing that speaker to speak, even though it was just like a volunteer member who was doing the speaking. Having that sort of affirmative representation and warranty from the speaker can really help to protect your association. So yeah, if you can't do anything else, just get an email, giving permission, but it's a much better idea to have a little more robust form. And I'm not talking, these are all one-page documents, and I try to write them without, with as little legalese as possible, so they're not intimidating to folks. Make clear for your authors, for instance, you're not asking them to give you copyright. It's just permission to publish, period. Pretty simple, so they don't get intimidated and they're not reluctant to sign.
Thank you. Becky, I think you have a question you'd like to ask.
Yeah, so this is non-meeting related and kind of a basic question, but as we, originally when we did the state shutdown and people were working from home, and now we're getting to the point to where we have employees that are quarantining and stuff like that. Are we as an associate or as anybody required, or should we be providing the same equipment to all of our employees, no matter their status? So what I mean is, we have some employees that are exempt salary, some that are non-exempt, some that are hourly, but yet some of them don't have the ability to work from home. Are we legally required to give everybody the same opportunity to do that? Or does that even matter during COVID times?
It does matter, and it is an important and difficult issue. And there's no black and white answer for you. There's no law that I can point to, federal or state, that says you have to do that. What we're dealing with is ways that other laws could be applied to that situation in a way that could be legally problematic for your association. I'm mainly talking about anti-discrimination laws like Title VII of the Federal Civil Rights Act, and disability protection laws like the Federal Americans with Disabilities Act, and many states have their own versions of the ADA, which apply to smaller employers. The ADA only applies to, I think, employers of 50 or more full-time employees. Many of your associations are probably less than that, but there are many state laws that apply like for as few as one employee, like we have here in DC. I don't know what the case is in Kansas, but and the reason, so first off, like the ADA and the state equivalents, they generally require that if someone has a disability, you, the employer, have to make a reasonable accommodation to allow them to do their job, as long as that accommodation does not pose an undue burden on your association. And now, granted, most of your situations here are not going to involve someone with a disability, but you'd be surprised what allegations people make. And so there have been many instances where association employers, is even pre-pandemic, are allowing certain employees to work from home and making accommodations. Because I have one I dealt with, I think in January, February, where the employee, it was essentially like a version of PTSD, and she said that she was, she was getting scared of all these people coming up from behind her and things like that in her cubicle. And anyway, we made an accommodation to allow her to work from home, and then the pandemic hit, which made it a bit easier. But for instance, on the discrimination laws, whether it's federal or state, if the result of, if the employees, for instance, that don't have the necessary, internet connection, Wi-Fi and computer equipment and other things at home to be able to work from home, if they are disproportionately in protected classes, right, like being African-American, being Hispanic, being in any class protected by laws governing race and ethnicity and national origin, and plenty of other protected characteristics under both federal and state law, If you're disproportionately affecting those people and they're having the adverse impact of this, you could be faced with potential discrimination claims as a result of that. And so if that were in fact the case, then you might well be, it might well be advisable for you to provide equipment to those who can't afford it. I can tell you that most associations, what I've seen, have taken the position, not really so much driven by law, but just by equity, that, for anyone that doesn't have the necessary equipment and whatnot at home, that they are providing it to them. Some associations are just providing like a monthly stipend during the pandemic to all employees to be able to use it for at-home expenses, things like that. I'm not saying you have to do those things. That's why I said it's not an easy answer here. But there are some risks in terms of potential disparate treatment of different classes of employees that you might want to take into account. But I mean, at this point, we're in December. Like, I'm wondering how this is, if everyone's been working remotely, haven't you already had to deal with this issue by now?
No, actually, we it's just now coming up again because we've all been back in the office, and now we have employees that are starting to quarantine, are having to quarantine, and the majority of us have the ability to work from home, but we have a couple that cannot. And so it's starting to come up again as to, well, why can this person take their laptop home, but I can't take my desktop monitors and computer and everything, and you give me internet, and all that kind of stuff is now coming up because there's one or two employees that just don't have it. And we made it through because during the first part of it, they worked from the office because nobody else was there.
Yeah, you really might want to consider, I mean, if it's as easy as letting them take their desktop home, that's a pretty easy fix. And if you need to give them some small subsidy to cover, some basic Wi-Fi service or something, it might well be worthwhile.
All right, we have one more question in here. I know we're running up on time, but if you're going to rebrand your foundation, including changing the name, are there any big legal considerations?
So, I mean, the same answer would apply to your association as well as your related foundation. And actually, I have a great article about related foundations of associations that I will send you that talks about, not about this issue of the name and rebranding, but all about the relationship between your foundation and your association from a governance, from a management and operations perspective. What are a lot of it's based in the federal tax code, because most associations are tax exempt under 501c6, and most foundations, related foundations, are exempt under C3. And in order to protect the separate legal and tax exempt status of the two entities, there are certain kind of rules of the road in terms of how those organizations interrelate, overlapping boards, money flow, donated services, staff time, things like that, office space from one to the other. And the article talks about all of those rules, and I'll send a link to you guys for that. But as to the name, so the first thing you need, there's two areas of law that come into play. One is trademark law and one is kind of corporate law. So from a corporate law perspective, the name of a corporation, like a nonprofit corporation, comes from the state of incorporation, wherever state you incorporated. In your case, for all of your cases, it's probably Kansas. So you file articles of incorporation originally to incorporate the entity. If you want to change the name, you file articles of amendment, an amendment to your articles of incorporation to change the name to something else. So you have to do it that way. And of course, you have to be sure that the name is available, meaning no one else has registered that name, that exact name, in the state. Not likely going to be a problem for you guys in this situation, but you have to make sure it's available. So that's how you legally effectuate the name change. One thing to keep in mind is that this is all governed by the state, the Kansas Nonprofit Corporation Act, as well as your own governing documents like your articles of incorporation and your bylaws. For associations that have voting members, I don't know exactly how the Kansas Act deals with it, but most of the state nonprofit corporation acts say that if you have voting members, the voting members have to vote to amend your articles of incorporation as well as the board, that the board can't do it alone. So if you are amending the name, if you're changing the name of your association, just keep in mind a membership vote is likely going to be required. If it's a related foundation, they generally don't have members, or maybe the association is the sole member. So that's not a big issue in terms of the voting to change the name, but you have to file those articles of amendment to change the name of your foundation. But then the other part of it is trademark law. There's federal trademark law and there's state trademark. Every state has their own trademark office. If you guys are only operating in Kansas, then you really don't need a federal trademark registration that you get from filing with the U.S. Patent and Trademark Office. You can just file in the state of Kansas, whatever the Kansas Trademark Office is called. But the thing you want to do is you need to do a search or have someone do a search to clear the new name to make sure it is legally available and it's not going to infringe on anyone else's same or similar name that could be confusingly similar to the public. So you want to be sure you do that, you clear it. You have someone do a trademark search. You're searching data, but they're searching databases, internet, things like that. And once you clear it, then you want to register the new name with your state trademark office. It gives you added protection. It's an important step to take. Highly recommend that you do so, especially since you guys are state associations for the most part. And I know some of you are national associations that are based in Kansas. If for national associations, you want to do this process with on the federal level. But for ones that are only operating in the state, you can do it on the state level, and it's fairly inexpensive, but you really do need a trademark lawyer to help you do that. Obviously one in Kansas. So I hope that answers your question.
Great. Not seeing any other questions. If anybody has any, go ahead and type them in real quick. We're running up on time here. If not, Jeff, thank you so much for being with us today and for sharing all these great resources. We really appreciate it. We're coming up on a break here, and everybody, our next session will begin at 10:30. Be sure to check the links that Christy sent out yesterday because it will be a different link. And she also sent out our silent auction items, which will close at noon on Friday. So be sure to check those out. And I think that's it, Jeff. Thank you so much again. And Christy, is there anything else?
Nope, just thank you to Jeff very much. I think we could have stayed here probably all morning, so we greatly appreciate it. But everybody take your 30-minute break, check your email, do what you need to do, and we'll see you back and we'll talk about some of the things we talked about for the last hour. So thank you all so much.
Enjoy the rest of your conference.
Thank you.
Thank you.